Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good afternoon. Do we have, let me see who we have here. Mr. Cox, can you hear us?
Yes, I can, Your Honor.
But you can't, can you see us?
I can see you. For some reason, my video will not start.
All right, we understand that. Okay, Mr. Sun, can you hear us?
Can, Judge Niemeyer. Good afternoon.
All right, we'll begin with the first case of Lightfoot versus Georgia Pacific Wood Products. And Mr. Cox, we'll hear from you first.
Thank you, Your Honor. May it please the court. My name is Sean Cox, and I represent the appellant Christopher Lightfoot here. Mr. Lightfoot developed sinonasal cancer caused by the exposure to wood dust from Applee's products. Christopher Lightfoot was exposed to wood dust from Applee's products from the ages of 6 to 18 in approximately 1981 until the fall of 1992. Now, Christopher Lightfoot filed suit based on these exposures and the failure of Applee's to warn about the cancer risk associated with their products. The district court granted summary judgment against Mr. Lightfoot on a claim that there was no evidence showing a duty owed to actually warn about the dangers associated with their products, and that there was no evidence of causation. Now, regarding the duty to warn, in North Carolina, a manufacturer has a duty to warn about dangers associated with its products if it knew or should have known of those dangers. And courts look to state-of-the-art evidence in order to determine whether a manufacturer knew or should have known about the dangers associated with its products. And this court has defined state-of-the-art evidence as all of the available knowledge on a subject at a given time, and this includes the scientific, medical, engineering, and any other knowledge that may be available. That's how this court has defined state-of-the-art evidence. But the district court did not follow that definition. The district court limited its examination of the state-of-the-art evidence solely to whether OSHA had declared and designated wood dust as a carcinogen, and the organizations upon which OSHA relies on, primarily the International Association for the Research of Cancer, which is known as IARC. Now, without a designation from IARC or OSHA that wood dust was cancer-causing, was a carcinogen, the district court found there could not be a duty to warn. Now, this ignores this court's definition of state-of-the-art and narrows the state-of-the-art examination to solely a designation by a government agency that a substance is toxic. And this, by extension, limits the duty to warn for any manufacturer about the dangers associated with their own products unless a government agency has told them that they must by designating it as a cancer-causing agent. Now, the district court limited its consideration to the 1995 IARC monograph, which examined wood dust.
Counsel, yes. This is Judge Richardson. If I can interject for just a second, I want to make sure, maybe take a step back and make sure I understand the framework that you're asking us to apply. In order to have a duty to warn, in this case, you agree that the state-of-the-art evidence had to show that wood dust was a known carcinogen, right?
Well, I would phrase it the way the Eastern District of Virginia recently did so, which is if experts in the field would have known about the hazard, then the manufacturer had a duty to warn about it, because manufacturers are held to the standard of
but when you use the word hazard there, and I just want to make sure I'm understanding what your distinction is. By hazard, you mean carcinogen, not that it causes bronchitis, for example, right? Because it gets in your lungs. The hazard we're talking about is that it causes cancer.
Yes, Your Honor.
Okay, and the important part of a carcinogen is that it causes cancer. It has a causal relationship between the wood dust and cancer.
Yes, Your Honor.
Okay, and so what I just want to make, this is still framework. I'm not talking about the evidence, but the evidence that you're giving us needs to show that, right? A causal link between the wood dust and the and causing cancer. And I guess what I'm getting at is it's not sufficient, is it? If there's merely a correlation, it has to be causation.
Yes, Your Honor. I suppose I'm looking at as a causal relationship.
Okay, and so, and you, I mean, just as a matter of basic sort of, linguistics and statistics, correlation is not itself causation. There's a whole sort of series of spurious correlations that exist. The question is whether there's a causal link. And I want you to talk about the evidence, but I want to understand that that's what we're looking for in some of the evidence here, that there is something that's not just correlation, but shows a causal link between the two.
Okay, Your Honor. There's actually a lot of evidence that shows that causal link, not just correlation, but a causal link between cancer and wood dust. And it wasn't just discovered in 1995 when IARC published a monograph designating wood dust as a carcinogen. It dates back, even with IARC, it dates back to 1981 when they were examining the furniture making industry. And so in their examination,
take that example, and then I'll let you go on. But take just the 1981 example where they describe an association between workers in the furniture industry and cancer, right? That describes, I think, quite well a correlation. What it does not do is establish causation, right?
Well,
it indicates that whatever it was, 11 out of 72 of the people that studied with that cancer had worked in the furniture industry. And that's a correlation, and it may be an interesting correlation, but it itself doesn't establish causation.
Well,
right?
Your Honor, it was not just that certain number of people that worked in the furniture making industry developed cancer. It was also that those individuals, the risk of developing cancer, where it was elevated, was in those exposed to wood dust.
Right.
Now,
that again is a correlate. What I'm trying to get you to explain to me is why that's something other than correlation.
Well,
right? So it correlates. So in other words, those exposed to wood dust have or show up with greater cancer, and that's a correlation, right? And there are all sorts of correlations that exist.
Yes.
The question is,
now,
why is that not causation? Why is that causation?
For one thing is that you can't just look at the IARC analysis there. Is you look at also all the foundational research that dated back to 1965.
Okay, I understand that, but stay, before you move on, Mr. Cox.
Between wood dust.
Mr. Cox, before you move off of the 1981, I just want to make sure that we're clear. That itself does not show causation. You want to point to something else. So do you agree with me that the 1981 IARC shows correlation only and not causation?
Let me interject and say it would be helpful in hearing your answer to Judge Richardson's question if you would tell us what you think the difference is between correlation and a causal link. Because if we're not on agreement on that, then the answer here may not mean very much. What is the difference that you view between a correlation and a causal link? If the understanding of correlation is not enough, you must show a causal link.
I think the difference is when you are not looking at one simple example of it, but you have a number of studies that show this same thing on a repeated basis. And also, I think you look to the opinion of experts.
When you say shows this, you're skipping over the question that's asked. What does it show? You say there's numerous things showing what?
It's showing, and this is in the words of an
No,
expert.
showing. I want you to tell me what it showed.
It shows that.
I think the question that, as I understand Judge Wynn, was let's find out what these studies are showing. Is it a correlation or is it a causation? And is there a difference? And how do you define the difference between the two?
Well, I think that the where you would look to that is, for one thing, is look to where the experts define it as
Not
whether
where,
it's causal.
what we're trying to find the meaning of some words, the terms you're using, if you would define them for us.
Well, Your Honor, it's a correlation is more along the lines of a coincidence. Is that one, simply because one item follows another does not prove causation. But when you have an abundance of evidence showing the same connection, and you control for other factors, such as you eliminate that it is caused by perhaps formaldehyde or some other causative factor that might be involved in furniture making, then you get to reach to causation, so that you're not just looking at whether one thing happened and then another. You're looking at whether this one thing happened, exposure to wood dust, and then cancer happened, and you're able to eliminate, other causative possibilities, other items which might explain the correlation. And here, IARC eliminated those and found that the connection was between.
Mr. Cox, can I interrupt you 1 second?
Yes, please, Your Honor.
We're having a technical problem. I think we've lost one attorney.
Yeah,
Mike, are you on?
Yes, sir. We've lost Mr. Sun, and I'm going to give him a call, try to get him back in. So please stand by, sir.
find the difference between correlation and causation, and you were summarizing the notion that numerous correlations could lead to something more. I think that's about where you were.
Well, it's perhaps a little more nuanced than that. It's essentially that a causation or a causal relationship is that if you can change one variable, that will result in a change in the result. That it's not just that two things happen together at the same time, but that you can actually manipulate the change and you can show causation that way. Now, if you take the number of studies that were examined in IARC and by OSHA and NIOSH and over the years during the exposure period, you see there is actually a causal relationship that when you increase exposure to wood dust, you increase the risk of cancer. Now, what's most important, I think, in looking at this distinction of what is considered causative as opposed to a correlation is you look to the experts. We had an expert epidemiologist who actually worked with IARC in crafting these monographs, Dr. Aronson, and she interpreted the 1981 language addressing wood dust to be already in 1981 a causative statement. And what's more interesting in that is
let me ask you something.
Actually says that.
Let me ask you something on that.
Yes, Your
Honor. If you have an expert that's looking at the data and ignores the words but draws her own conclusion that this statement means more than what it says, that's hard to impute to manufacturers who are reviewing the data and are reading just the words. And the words in 1981 talk about a correlation, and they talk about it in a particular workplace and with particular types of woods, furniture woods. And the question is whether that is something on which a wood seller would have to draw the conclusion that there was a cause between sawdust and the cancer.
Well, Your Honor, I think that I'm sorry. I think the important thing is to not just look at the 1981 IARC or just look at the 1995 IARC monograph, but we can also look directly at OSHA. OSHA actually stated in 1989 that exposure to wood dust has long been associated with a variety of adverse health effects, including cancer. Now, additionally, NIOSH in 1987.
Sir, do you read the word associated to be any different from correlation?
I do, Your Honor.
Explain.
And I believe that.
Tell us why that is.
Well, because association isn't necessary. That doesn't mean that's not the same as correlation. There can be relationships that are associations that could be causation or it could be correlation. Now, in the interpretation of OSHA, they're not mentioning this in here that there is an association with cancer simply based on correlation. Otherwise, they would perhaps have said there is a correlation here. They said there is an association. And NIOSH, which in 1987 stated that, citing to a Canadian governmental report, that exposure to wood dust is convincingly associated with the development of cancer of the nasal cavity and paranasal sinuses. That's not just there's a correlation, that there's a relationship that they happen to appear at the same time. We're talking about a convincing association. That is causation. That would, to experts in the field, indicates that there is a causal relationship between wood dust and cancer. And if experts in the field would interpret or would understand that there is a hazard associated with their products, with these Appley's products, then the Appley's had a duty to warn. Now, the problem here is what stems from the district court's alteration of the state-of-the-art review and requiring, actually, and she stated this on page 16, 17, and 18 of her order, that she needed a state-of-the-art determination by a government entity before she would find a duty to warn. I see my time has expired, Your Honor.
All right, you do have some rebuttal. All right, Mr. Sun.
May it please the court, I'm Paul for Georgia Pacific and Warehouse.
The district court correctly ruled that Georgia Pacific Warehouser did not have a duty to warn that wood dust causes nasal cancer. And on that basis, the district court properly granted summary judgment. The only claim that Mr. Lightfoot pursues is a duty to warn claim. Under North Carolina law, that is a question of law for the court. There was no duty to warn here because the state of the art, and as this court has said in Horn, that's the culmination of the relevant research, did not establish during the exposure period that wood dust causes nasal cancer. Similarly, the state of the art established only that there was an association of increased incidence of cancer with occupations involved with woodworking. So it was not reasonably foreseeable, based on the state of the art, that a retail consumer who would be working in a hobby fashion in his own home wood shop using mostly softwood would be at an increased risk of nasal cancer. Georgia Pacific.
I don't interrupt you, but your colleague just said that we should read the word association to mean causation. Can you respond to that argument?
I can, Your Honor, and I can respond in two ways. First of all, Mr. Lightfoot's own expert, that's Dr. Jones, says association and causation are different concepts. That's at Joint Appendix page 1535. And also for reference for the court's consideration, the Federal Judicial Center's reference manual on scientific evidence, and I would cite the 3rd edition, 2011 on page 221, says specifically, association is not causation. Association is not causation. The court inquired, when would there be an ability to look and go beyond association to causation? And I can cite again to the court, IARC, the International Agency for Research on Cancer, the definitive body, it's not a governmental body, but the definitive scientific body to determine when exposure to some substance causes cancer. What IARC says is, and this is at Joint Appendix page 982, that you look for in association, you look for strong associations, you look for associations in different circumstances of exposure, and you look for when the risk of disease increases with the amount of exposure. And on that last detail, Mr. Lightfoot argued that there was evidence in those studies or in the IARC reports or in NIOSH that the risk of disease, the risk of getting cancer increased with the amount of exposure. Your Honors, the state of the art did not show that. There were no studies showing how increases in exposure would or would not lead to increases of cancer. Again, Mr. Lightfoot referenced the NIOSH survey, and I can ask the court to look at Joint Appendix page 2189. There were no reports or studies showing that with the increases of exposure level, that there would be increases of cancer. So
is an association more than a correlation?
No, I don't agree with that either, Your Honor. Association, those words are the same. They have the same meaning. And again, to highlight where counsel has, or Mr. Lightfoot has focused both in the brief and in the argument today, looking at the 1981 IARC report or the 1987 NIOSH report, and those are quoted at length in Mr. Lightfoot's brief. In neither of those is there any statement about wood dust causing cancer, that wood dust is a carcinogen, that wood dust is carcinogenic, or any of those. There are no statements to that effect. The only statements of any import in either of those reports, 1981 IARC or NIOSH, have to do with associations with certain occupations.
So let me ask just out of, I guess, curiosity, the studies that would at least give some rise that perhaps would support a causation if there was such a thing, are those typically industry-driven studies, or are they studies, governmental studies, or academic studies? I mean, how does that happen? In particular, and let me tell you where I'm going, and because I wanted to kind of explain to it, if there is some indicia, maybe just a correlation or association that this happens, it would seem that that would in turn inform the need to do some studies. So at that point in time, if we're talking back in 1981, if we at least we have a correlation, and we fast forward up to the year 2000, you would think that given that correlation or association as being indicative back then, somebody would do a study or someone would begin to undertake this. And my question, and of course, I don't think it's determinative, but at least it seems to indicate something. Is that industry driven for the most part, or is it government, or where does that lie? I know OSHA was involved, but where does it lie?
Your Honor, there were many academic research studies conducted before 1981, between 1981 and the end of the exposure period in 1992. Those are cited and relied on, evaluated by IARC. That's what IARC does. It looks at all of the relevant studies, and those were, for the most part, academic studies. Your Honor, there was also a government NIOSH study in 1987, but there was a lot of focus. Your Honor is exactly right. And what IARC does is it looks at whether there is evidence to suggest that an exposure may cause cancer, and it investigates that. That's what it did throughout that period, and not until after the exposure period, 1995, did IARC reach the conclusion. It says its evaluation at that point was that wood dust causes cancer. Do we take it that if an incident occurs where someone does in fact contract this level of cancer, and then subsequently there are studies that show a causal link, because it didn't exist then, for the most part, there would be no liability that would arise in that instance? That's exactly right, Your Honor, and that's what the Horn case says. Horn says,
are we to take it that as of today, there is no study or nothing to show a connection, a causal connection link with the salt wood dust and this form of cancer?
No, Your Honor. In 1995, which is after the exposure period, IARC evaluates wood dust and did conclude that wood dust causes cancer. So there was a conclusion reached, and again, in the language of the Horn case, the culmination of the relevant research, and to Your Honor's point about looking backwards, again, that's what Horn says is not appropriate with state-of-the-art evidence. State-of-the-art evidence should not be used retroactively to discredit conduct before the culmination of the relevant research. And here the relevant research is, the relevant question is, does wood dust cause cancer? And there were no conclusions reached. There was no culmination of the research during the exposure period in that regard. The studies were ongoing. The studies were frequent. And the studies went all the way up until 1995. In that IARC report, which again is from 1995, it cites numerous studies that were published after the exposure period. And I could cite pages at 1161, 64, 65, 70, 71, 72, et cetera. That's from the bibliography. But to Your Honor's question, those studies are ongoing. And it was it was the Definitive Cancer Rating Agency, IARC, and that's not Paul Sun or Georgia Pacific or Weyerhaeuser calling IARC the Definitive Cancer Rating Agency.
Let me ask you this. Could you also prevail on foreseeability that there's no jury question on that? And if we did that, would we need to answer this state-of-the-art question?
Your Honor, it's really another way of looking at the same thing. So yes, because what again, this court has said needs to be the focus is when the state-of-the-art, when the knowledge was available on the subject at a given time, what was known and when the knowledge was available, and to the question again about what's being studied all along here during the exposure period, it is in the occupational settings. There were no studies in non-occupational settings. So the foreseeability of someone not in an occupational setting, but rather in a home woodworking environment, there were no studies in the non-occupational settings. The studies that were going on in occupational settings were mixed. They were pointed in the direction often of saying that there was a higher incidence of cancer with certain occupations, but not exclusively, and not with every kind of occupation that was being studied where wood dust was involved. As of 1981, for example, IARC found that association only with the furniture making industry, not with various other industries having to do with, again, wood dust exposures, cabinetry, joinery, sawmilling and the like. There were no conclusions reached, no state-of-the-art evidence supporting anything with that regard. And again, I'll highlight, and I've said this, but not to repeat it too much, there were no studies at that time and all the way through the exposure period showing how increases of exposure would or would not lead exposure to wood dust, would or would not lead to increases in the incidence of cancer. So translating or applying, and Mr. Lightfoot argues, well, you can just translate those non-occupational findings and research into a non-occupational setting. You can't. There are differences. There are no such studies. There are no findings by any cancer rating agency. There's no exposure increased incidence reports.
Can I ask you a question on that? That's sort of more of a framework question. Do you agree that it is not necessary to have a government agency make the finding? So in a different case, obviously not this case, if there was an academic study that had been conducted in 1988 that definitively concluded that wood dust was a carcinogen, that would be sufficient, wouldn't it? It wouldn't matter that OSHA didn't do it until 1995 if, the lab at Clemson University found that wood dust was a carcinogen. That would be sufficient. The point of OSHA and IARC here is that that's the best evidence of that information, not that it was itself necessary to make that finding. Is that fair?
Your Honor, I agree that there doesn't need to be a government finding at all, but I would say to the extent there might be one study that shows a causal connection, that would, I would contend, not be sufficient. If there are other studies that aren't definitive in that regard, that aren't finding that kind of thing, you don't, to impose a duty to warn, pluck a single study out and say, well, that's enough. There has to be, again, to use the words of the Horn case, the culmination of the relevant research. If there are multiple studies, and yes, Your Honor, it certainly does not have to be a finding by a government agency. IARC is, their task, what they do is determine when exposures to subjects, to agents, cause cancer. Could you find a duty to warn where IARC hadn't done that? Maybe, but that's not the case here because there weren't any studies showing a causation link between wood dust and cancer during the exposure period. And to the question about foreseeability, it ties back again to state of the art, and I mentioned the Lorman case, and I think that again sheds the light on how appropriately the district court applied the analysis and why the conclusion was correct that it was not reasonably foreseeable. And what Lorman said there is the state of the art, when the state of the art included knowledge that people that, such as the plaintiff, were at risk. And so the question is, when the state of the art showed that people such as Mr. Thomas Lightfoot, the father, and his son Christopher Lightfoot were at risk, and the state of the art did not show that. The district court, again, did not artificially, this is a phrase out of the Mr. Lightfoot's brief, create an OSHA litmus test or create something that was, that's page 13, create something that was unsupported by law. All of what the district court did in this case is guided by this court's directions in how to focus on state-of-the-art evidence and what state-of-the-art evidence means. It focused just as this court in Lorman first and then Horn said it should, dealing both with whether there was a duty based on the state-of-the-art evidence. I will note that in Mr. Lightfoot's briefs, he does purport to represent to the court that there are studies outside of the occupational context. First of all, that's not correct. At page Joint Appendix 995, IARC says that there are no studies outside of the occupational setting. But what Mr. Lightfoot cites to is a research, it's a case series study. The author is someone named Lingaman. It's cited actually a couple times in the Joint Appendix, 2171 and 2540. And in describing the 72 people who were studied and were found to have nasal neoplasms that were malignant, one, it was reported, one had a home woodworking environment. That's not the kind of study. First of all, there's no study of non-occupational settings. It is an anecdotal finding of 1 out of 72, and that's the only instance that Mr. Lightfoot is able to cite at all for whether there was any focus on non-occupational settings.
So as you're concluding here, I just have a curiosity question. It doesn't matter that this would be a minor who, if his father is picking up lumber from a place they know his father, would it matter if you could show that they knew it would be used around children, and if there were studies showing they had a higher propensity for this, would that be of any consequence here? Or at least, when I say propensity, I don't want to get mixed up with causation and correlation, but you see what I'm just asking, does it matter of him being a minor have any import in this kind of legal discussion at all?
Your Honor, I think it could, and again, that's what Lorman says. You look at the kind of plaintiff involved. In that case, it was someone working in an asbestos plant, and the question was, are they exposed to raw asbestos or products with asbestos? Here, the particular distinction is Mr. Lightfoot is working in a home woodworking environment. But yes, Your Honor, I think if there were studies, it would go to foreseeability. Would it be foreseeable for a reasonable wood lumber manufacturing company like Georgia Pacific or Weyerhaeuser to warn? That would be informed by the state-of-the-art evidence that evidence, if it showed that there was some causal relationship between exposure to wood dust and an incidence that increased with younger aged claimants. And on that ground and on the other grounds advanced by the district court and in Georgia Pacific and Weyerhaeuser's briefs, we would ask the court to affirm the district court. Thank you.
Let me just ask you one question. This is just a curiosity. How are consumers today warned about this risk?
Your Honor, there isn't anything.
If I go to Home Depot, I'll just get it more specific. I have bought lumber at Home Depot over the past years, and I can't recall ever seeing a notice anywhere that warns of this risk. The first time I've learned of this risk is in this case. And I'm just wondering, just as a curiosity, how the consumer today is notified.
Your Honor, there isn't anything in the record in that regard, and I'd be reluctant to represent what the situation is without being able to point the court to something in the record in that regard.
All right, that's fair enough. Okay, Mr. Cox.
Thank you, Your Honor.
Yep.
Thank you, Your Honor. I would like to point out that the study that was mentioned earlier regarding the home workshop exposures, that was seen as credible and important enough to be cited by IARC in the 1987 monograph, as well as by NIOSH in its 1987.
Yeah, but wouldn't that be, not to get to the too fine point, but IARC undertakes to try to report and review all of the studies that are done before it draws conclusions. And it seems to me if that is a study that took place, whoever looks at the substance of it would have to draw a conclusion as to whether one person out of 72 who was exposed to workshop dust got cancer, or the 72 cancer victims, only one worked in a home workshop. It seems to me somebody reading that and collecting evidence as to what the causation element might discount that type of study much more than a more comprehensive study or more persuasive evidence. I think it gets difficult for us as a court to start assessing and weighing the various individual studies if we get an idea of how many there were and who was reviewing them and the industry's knowledge of them, requiring them to warn the public.
Well, Your Honor, actually, I believe it's the jury that should be examining the state-of-the-art evidence with the benefit of expert testimony to explain it, because again, these monographs are not written for lay people or lawyers or even judges. They're written for experts in the field. And so experts can present to a jury the state-of-the-art evidence, and the jury can weigh it and determine whether the manufacturers knew about the dangerous propensities associated with their products. And that is what the law is the duty to warn is in relation to the product's dangerous propensities, which are known or which by the exercise of care commensurate with the danger should have been known by the manufacturer. That's the standard. It's not whether the product contained a carcinogen.
Counsel, can you give me a case for the proposition that whether a duty to warn exists is a question of fact for the jury?
I don't have it off the top of my head, Your Honor. I'm sorry, but
alternatively, can you respond to your colleague's suggestion that there was no study prior to 1992 that connected an increased risk of cancer with the increased amount of exposure to wood dust? Can you point me in the JA where that study that you referenced in your initial argument exists?
Well, Your Honor, there are numerous studies that examine this, and I think IARC in 1981 specifically stated that the increase in cancer risks were among those that were exposed to wood dust, as opposed to those that weren't.
I just want to be clear. The answer to my question of where the increased risk results from increased exposure, you're pointing to the 1981 IARC report. Do you have anything else you'd like me to look at when I consider that question?
I would like you to look at in JA 2540.
Okay.
And
Anything
that's in
else?
the 1987 NIOSH review. And it's citing to the Canadian report that shows that wood dust is convincingly associated with the development of cancer. I think that I think that we're perhaps even getting off the path.
I thought the question was the risk increased with the increase of the dust? In other words, a more intense dust, does that create a higher risk?
I'm not sure that that's the question that is asked by the science here. It's whether
it was the question that I asked.
Oh, I understand, Your Honor. What I'm saying is that the introduction of wood dust, that is an increase from no wood dust, as which in the furniture making industry, the context, there were groups that had no wood dust exposure and groups that had wood dust exposure, and not require a scientific causation statement by a government agency or even any study. What it requires is that if a manufacturer knows and that substantial risk, that's what they must warn about. There's nothing in the law that says there must be a determination that something is carcinogen. Thank you.
Thank you. We can't see counsel. We would normally come down and greet counsel. We can't even greet you in face, but we do thank you for your arguments. The technology, as you know, depends in great respect on the weakest link from your place to our place here. And so we're unfortunate we didn't get to see you, but thank you for your arguments, and we'll proceed on to the next case.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. All right, looks like I'm going to call the case United States versus Caldwell. Mrs. Okwara, can you hear me?
Yes, Your Honor. Good afternoon.
And Ms. Ray, can you hear me?
I can, yes, Your Honor. Thank you.
Okay, we'll proceed. Ms. Okwara, you're up first.
Good afternoon, Your Honor. May it please the court, Chiege Kalu Okwara for Mr. Caldwell. We're asking this court to vacate Mr. Caldwell's convictions on all the 4 counts and remand the case for a new trial. I filed a Rule 28J letter yesterday with regards to count 4 of the conviction. I think based on Rahab, as well as this court's decision in USA v. Medley, that's dispositive because Mr. Caldwell was convicted of possession of a firearm by a convicted felon, and that was prior to the Rahab decision. The indictment, the jury instructions did not have the knowledge requirements. So I think that takes care of count 4. That count 4, his conviction should be reversed on that count and sent back.
Counsel, can you answer this question for me? So you raised for the first time the Rehoff issue in your reply brief, which was right after Rehoff was decided. And so I don't believe it's waived as a result of not being raised until the reply brief. But when I read the reply brief, there's no argument made as to why you satisfy the 3rd or 4th prongs of plain error review. There's no argument at all. And so what I'm curious as is for failing to provide any argument or record support for those 2 prongs of plain error, why we should not consider the Rehoff argument waived given the failure to brief it in the reply.
I believe I raised it when I talked about Gary in my reply brief, where I talked about that the lack of knowledge, and I addressed the issues of plain error, the 4 prongs. And then obviously the Medley decision is a
which can you just give me a page that you want me to look at? And then let me ask it a slightly different way. Assuming that you did not, do you agree that it's waived?
I wouldn't agree that it's waived, Your Honor, because the case is still on appeal. This court has entered the decision in Medley that said we have previously addressed the issue in the case of a guilty plea, which was Gary. And then in Medley last year, you addressed it in the context of a jury trial. And the facts in Medley seem almost on the same on the same prong with Caldwell in that it was a jury trial. He was convicted. The indictment, the instructions, all did not contain that. And I believe in Gary, this court actually held that failure to include that element is a structural error that requires the case to be remanded.
Let me ask you this. During the jury trial, you spoke to the jury and said he stipulated to being a convicted felon. That is true. And that is exactly why he knows that if he's previously been convicted of a felony, he cannot possess one. And that's why he did not possess one in this case. How do we handle that argument, which you basically took from the jury and said that's not an issue in this case?
We entered the stipulation, and maybe in light of current law, the stipulation is specific and only said as Mr. Caldwell has been convicted of a felony. And the stipulations appear on pages 154 and 155 of the joint appendix. And then
I'm not talking about the stipulation. I'm talking about this statement. And that it is exactly why he knows that if he's previously been convicted of a felony, he cannot possess one. And that's why he did not possess one in this case.
Well, I guess I misrepresented the stipulation of my client to the court, because his stipulation appears on page 1201 and 1637 of the joint appendix. And all it says is that he had previously been convicted of a felony. So if I said that, then that's an effective assistance of counsel on my part, because I was not authorized to give that kind of concession. What we stipulated to and what the record is and what the jury instruction says, how the court instructed them was to say he has been convicted previously of a felony. So that fact is not disputed. And the questions the jury had to answer was, one, has he been convicted of a felony? One, and two, did he possess a firearm? So I said, we're not contesting the fact that he's been convicted of a felony, but we're contesting the fact that he possessed a firearm and that he did not possess a firearm in this case, or firearm.
Now, you do know that the Supreme Court has this issue actively. They granted cert on this.
I know in the Gary case, yes, Your Honor.
And Greer, yes. And so what are we supposed to do with that?
But the court knew about that when this court issued its decision in Medley. I believe it's
I know both Medley and Gary are basically subject to further disposition by the Supreme Court, right, on this issue?
But at this time, it is the law of the circuit.
All right.
No, Medley has been vacated. It's pending en banc review. It is not the law of the circuit.
Okay, I wasn't aware of that. So I still maintain my argument. At least Gary is still the law of the circuit. The Supreme Court has accepted it. I don't believe there have been any arguments or that it's been overturned, and that was an en banc decision. So it's still the law of the circuit in this case.
All right. Got anything further?
And Your Honor, the other big issue that I raised was, well, it's not just the only issue. The other issue was the attorney conflict. Mr. Nicholson, Mr. Caldwell, my client, is accused of committing an armed robbery with two individuals, Mr. Cole and Mr. Mitchell. Mr. Caldwell never entered the bank. Mr. Cole and Mr. Mitchell were the ones who allegedly entered the bank. Mr. Caldwell was initially prosecuted in state court. Mr. Caldwell had been represented by the Public Defender's Office in Charlotte, Mecklenburg County, for at least, based on the records in the JA, from at least 2013 through 2016. He was charged in state court. Mr. Cole was also charged, and because the Public Defender's Office was representing Mr. Caldwell, they farmed out, gave away Mr. Cole's case to an outside counsel, Mr. Sanders. After the jury hung in Mr. Caldwell's case the first time, the state indicted Mr. Mitchell, and Mr. Nicholson of the Public Defender's Office started representing Mr. Mitchell. I found out about that when Mr. Caldwell's case was scheduled for retrial in May of 2018. I moved to disqualify Mr. Nicholson from representing Mr. Mitchell because it was a conflict. The judge overruled that. It was a conflict. I cited cases, the North Carolina State Bar rules that say a public defender's office is treated like a law firm, and you cannot represent clients with competing interests in the same matter. There is no doubt that Mr. Mitchell, Mr. Caldwell, and Mr. Cole were charged in the same matter. And if the public defender's office represented Mr. Caldwell, they cannot turn around and represent Mr. Cole and Mr. Mitchell. The court overruled that, citing a case from Iowa that said that there was no actual conflict, but the Iowa case is inapplicable because in that case, the defendant actually had no problem with the attorneys representing him and actually asked the appellate court to vacate the order that disqualified counsel. In this case, Mr. Nicholson's representation of Mr. Mitchell created an actual conflict for Mr. Caldwell. Not only did Mr. Nicholson create a juvenile court worksheet that probably did not adequately represent Mr. Mitchell's juvenile record, which the court did not allow me to go into. The court allowed Mr. Nicholson to confer with Mr. Mitchell prior to me cross-examining him. And after he conferred with him, that's when he came back and said, oh, the private investigator from my office came and talked to him and represented herself as his attorney, etc., somebody from his attorney, which were things that hadn't happened before. Mr. Nicholson, initially, after I filed the motion, the government contacted him. He said, oh, he didn't know anything about the case. He admitted that Anna McMillan, who represented Mr. McMillan, Anna McMillan, who represented Mr. Caldwell, had represented Mr. Caldwell. He had access to her files, although he didn't look at the file. He said when he found out about the motion based on the government's contact, he contacted the state bar. He cited different rules, Rule 17 and 19, and said the bar said that wasn't a conflict. I said, look at Rule 110. Rule 110 deals with specific conflicts of interest, and the public defender's office is represented as a firm. And if you had previously represented Mr. Caldwell, you cannot represent Mr. Mitchell in the same case because Mr. Mitchell is coming to testify against the client of the firm. During trial, the court took a recess. He contacted the state bar, and the state bar says, yes, you cannot represent him. It is a conflict. It is an actual conflict. And then he said, oh, but the state bar says there is a conflict, but I can represent him in this proceeding. And right after I represent him, on the pretext that I'm going to withdraw, those were his words. And then he withdrew after the representation. Like I said, the judge gave him break to go talk to Mr. Mitchell before I could cross-examine him. Whatever information he provided, that clearly was in conflict to the prior representation of Mr. Caldwell. Allowing him to create a juvenile court worksheet that wasn't a court record to represent it as Mr. Mitchell's delinquency history is clearly acting with information that would hurt Mr. Caldwell by not allowing me to properly impeach. When he found out that their office, let's give him the benefit of the doubt, he did not know until the government notified him of my motion. Question is, why didn't he withdraw right then and get a different counsel? Why was he insistent that he had to come represent to the court that the state bar said there was no conflict, cite the wrong rule, and eventually during trial said, okay, there is actually a conflict. So there was a conflict. It was contrary to interest to be representing Mr. Mitchell against Mr. Caldwell. And I think the conflict, if we look at the way the records were presented, the court allowing him to counsel Mr. Mitchell before cross-examination, and there's no doubt it was the same case. It is the very same case where the public defender's office had represented him. Mr. Caldwell's stipulation to a prior felony conviction was also the same conviction that the public defender's office, Anna McMillan, had represented him in prior years. The offense occurred in 2013, and he pled guilty to it in 2015. All those are in the joint appendix. So it's not just they represented him at one time and dismissed. Mr. Caldwell had a long ongoing relationship with the public defender's office. And the court seemed to be more preoccupied with making sure that the trial goes than making sure that Mr. Caldwell's rights were protected. And based on Mr. Nicholson's actions during the proceeding, it's not just the state bar said it's imputed conflict and that he should withdraw, but his actions during the trial, counseling Mr. Mitchell against Mr. Caldwell, preparing a worksheet that was improper, that wasn't a court record, referencing it as a court record. And I talked about some of those, like the juvenile court worksheet he prepared had a 2017 case number and was improperly numbered. And I pointed those are listed in the joint appendix. 2098, he prepared a one document worksheet, and I talked about how juvenile records are created, and those are clear on joint appendix 1395 to 1401. Mr. Nicholson should not have represented Mr. Mitchell at the trial. The court said you found out on May 11th and you filed the motion on May 18. He didn't testify till 11 days later. The way to avoid the conflict and make sure that Mr. Caldwell, his due process rights are protected is get a different counsel for him. Get somebody else. The government addresses that I'm against Mr. Mitchell testifying. I was more against having an attorney from a firm that had previously represented Mr. Caldwell to represent him and counsel him and participate in the proceedings at the jury trial. The North Carolina State Bar say it is a conflict and you cannot represent him, and bringing a case from Iowa that says, oh, you can, the court should not have allowed that, and the court should find that my client's rights were violated and that the case should be reversed for a new trial. Another issue that I wanted to address was the search of the vehicle. The government, after the armed robbery, there's no doubt my client never went into the car. He indicated that he was carjacked, even though the court or the government expressed opinion that nobody would believe that. There was a hung jury in January of 2018. He was convicted after a retrial, so it wasn't completely preposterous that he claimed that he had been carjacked and robbed by these people or taken. When they recovered, they found the vehicle. They said they found it outside the house. They towed the vehicle to the police station. After they towed it, then they went and obtained a search warrant. Search warrants in North Carolina are valid for 48 hours. This search warrant was valid for 48 hours. Although the officer testified at some point, or the court asked about impounding the vehicle was never impounded. The search warrant indicates, and the document shows that the vehicle was seized. But when you look in the joint appendix, some of the documents, it shows the vehicle was never impounded. That is why they went and got a search warrant, and the search warrant expired after 48 hours. So the search on December 9, 2016 was proper because they had a search warrant. And to say that, oh, we had probable cause to, or there's automobile exception to go get search the vehicle on December 22nd, I disagree with that because the government talks about on page 40 of their brief and says in US v. McCall, explaining that a reviewing court task when a defendant challenges the delay between the issuance of a search warrant and its execution is to decide whether a valid search warrant became invalid due to lapse of time. The search warrant in this case was issued on December 9, 2016, and it expired 48 hours later. So to go and search the car and say, in one breath, you say, oh, we had probable cause, we had automobile exception, and then you go and search it. You recovered the car outside a house, and that's why they went and got the search warrant. When
okay, why don't you wrap it up a little bit? We got you on overtime. So see if you can finish your thought, okay?
So the automobile exception doesn't apply because the vehicle was not mobile and the time the search warrant had expired and it was an improper search. Thank you.
Thank you, Ms. Carr. You have some rebuttal and we'll come back to you. Ms. Ray?
May it please the court. Amy Ray for the United States. Addressing first the Medley issue that Ms. Aquara raised for the first time yesterday, she did argue, she put the word Ray Haif in her reply brief, but there was no argument that identified the issues that this court decided in Medley. And as Your Honor, Judge Richardson has noted, that opinion has been vacated anyway. But the issues that she would have had to identify to properly present some argument would be, one, that the indictment was inadequate, and two, that the jury instructions were inadequate. Those words do not appear in her reply brief. She did not make the legal argument that would have supported relief under this decision, this court's decision in Medley. So she has waived, the defendant has waived that issue. And I would note, in addition to the argument that she made, I mean, we'll see what the Supreme Court does in Greer. I believe that this court should not wait on Greer and should hold that the argument is waived. If, however, it's not waived, then I suppose this court should hold this case in abeyance pending Greer and let the parties supplementally brief it if there's any question. I do note that Mr. Caldwell had previously been convicted of possessing a firearm as a convicted felon, in addition to what was argued.
Ms. Ray, can I ask you a question that you may not know the answer, and it's fine if you don't, but if we were to vacate the 922G conviction, on remand, would that affect his sentence? Or would he be a career offender under the 924C, the count 3, which would increase his statutory or his guideline range in the same manner that it was increased in his PSR?
Yeah, you know, I should know the answer to that, Judge Richardson. When I looked at it, I noticed that there were concurrent sentences and thought, oh, then it wouldn't make a difference. But you're right that I should have looked at the calculation of the guideline range. So I'm honestly not sure about the answer to that. And I apologize.
That's totally fine. That's a little off the wall.
Would that make a difference if with
perfectly. Judge Niemeyer, I'm sorry.
Yeah, I think we've addressed the effect or not on a sentence, but if there's a conviction that's vacated, that is something we have to fix, don't we, because of future consequences?
It depends on whether or not the court, if there is a sentence, okay, let me put it this way. In terms of analyzing under plain error, whether it had not affected the defendant's substantial rights, no, I don't think that would be part of the analysis.
If we vacated, we would have to either vacate or affirm 922G, right? The conviction.
Yes, absolutely. Yeah. But I guess I took Judge Richardson's question to go to, and maybe it did or did not, I don't know, but I was taking his question to go to the substantial rights prong of the plain error analysis. Because if it had no...
The fourth prong as well. I mean, the third and fourth prong.
Absolutely.
It makes no difference. Perhaps we would not exercise our discretion to notice it, even if it was a plain error.
Exactly right. And so I think one of the questions in that third prong or fourth prong would be, does it affect his sentence? Did it affect him at all? And if it didn't affect the guideline range on that count, then it wouldn't. I will say, well, I guess I won't take a guess. And I do apologize because actually I should have anticipated that question. So we believe that issue is raised. Turning to the questions, the other issues in the case. And one thing I guess I would also note is, of course, just in response to the reply brief, the Davis issue, there's no merit there because this court held in McNeil that armed bank robbery is a crime of violence under Section 924C's definition of that term. So there's no Davis in the issue in this case. That's the other argument that she made for the first time in her reply brief. Turning to the threshold issue of the search in this case, the police gave Mr. Caldwell more than the protections that are required by the Fourth Amendment because the automobile exception applies on all fours in this case to authorize that search. In Gastio-Borough, this court made clear that just because a car has been impounded or is in the custody of the police does not alter the fact that police still may use the automobile exception. That is to say that the Fourth Amendment authorizes the police to search that car for evidence as long as they have probable cause that evidence of a crime will be found in that car. And the police in this case saw through the window ample evidence to support that probable cause, a gun, clothing that matched the description, a ski mask. So they had probable cause to search the car. And actually, it was interesting as I was going back through the testimony again, Detective Cavedo explains why he got the search warrant. He just wasn't clear about the automobile exception. So out of an abundance of caution, he explains he got the search warrant. The fact that the search warrant, whether it exists or not, really doesn't matter in this case because the automobile exception applies to authorize both for the initial search and the search on December 22nd. Because in Gastio-Burrow, the court also made the point that the timing, the Supreme Court has made clear that certainly, at least within reason, there is no time limitation on the automobile exception. As long as probable cause would still exist and the car was sealed in this case, that probable cause continued to exist between the 13 days between the initial search and the later search. And at the end of the day, the Fourth Amendment is about reasonableness, and the officers acted reasonably when they couldn't get into the trunk and later returned less than 2 weeks later and accessed that area of the car. Addressing Ms. Aquara's conflict of interest claim, the district court acted very reasonably in this case. It went through an entire inquiry into what Mr. Nicholson knew. Of course, Mr. Nicholson did not represent Mr. Caldwell. He represented a witness. So there is no allegation that the defendant himself was represented by an attorney with any kind of conflict. What the allegation is that Mr. Nicholson represented a witness and that there was an imputed conflict of interest. In that situation, even though in the end the judge found that yes, or the state bar representative eventually said, yeah, there's an imputed conflict of interest, but Judge Cogburn did exactly what he should have done, which is to find out, could that possibly have affected Mr. Caldwell? And the answer was no, because Mr. Nicholson testified that he had no knowledge of Mr. Caldwell. In fact, he did not even realize that his coworker had represented Mr. Caldwell until 3 days before he was at the hearing himself. And so he said he learned on Monday, and the day of that hearing was on Thursday. That's the first time he knew. He had never seen anything related to his case. He didn't have easy access to his files. And there's no question but that Mr. Caldwell has to show some prejudice. If it's based on an imputed conflict and no actual conflict of interest, nothing that would have affected apparently Mr. Caldwell's interests, he's got to show prejudice. When his attorney did not act under a conflict, and he has not shown that prejudice. Your Honor, there were, at least 6 other issues raised in this case, and I'm happy to address any one of them that this court has concerns about. I guess the only other issue that was touched upon by Ms. Aquara in her opening argument was the juvenile records issue, but she seemed to raise that in the context of the conflict of interest claim. The juvenile records issue, again, Judge Cogburn acted very reasonably. He ensured that the government had done what it could, which was to obtain information, a list of prior convictions or prior juvenile adjudications that both Mitchell and Cole had received. And also, I note that the government did provide a lot of other information that was requested throughout this trial. And if the court reads the transcript, it's apparent that I think the government did. Let me
ask you regarding the conflict of interest. Was there any information provided indicating the practices within that office that the 2 attorneys worked in? In other words, were they in the same, I guess it's the same kind of work, but same supervisor? Any of that indicated there was some connection with them in the office in terms of how they might consult on the cases? I mean, we all do that, even judges do it from time to time, consult one another. And it's just a question. It's interesting the state bar took that position, and it's an ongoing issue in terms of what goes on. And was there anything in the record to indicate that?
Not at all, Judge Wynn. There's nothing in the record to indicate that. And what I would say was responsive to that question was Mr. Nicholson's statement to the district court that he did not know anything about Mr. Caldwell or anything about his case. So if there was any consultation between those attorneys, she kept his name out of it and enough facts for him not to be able to identify the case. And of course, if he represented Mr. Mitchell, he would have known about Mr. Caldwell and probably would have recognized the facts of the case pretty quickly. In any event, there's nothing.
did he continue to represent him even while he was a witness, or was another lawyer assigned during that time period?
No, while he was a witness, he was allowed to represent him because the state bar representative indicated that it would be okay for him to represent Mr. Mitchell during the trial, just as and Judge Cogburn, by the way, said, you know, Mitchell's going to testify. We can get him a new counsel if we need to. He was open to that possibility, but the state bar representative said it was okay for Nicholson to represent Mitchell during the trial, as long as Mr. Nicholson withdrew from representation after the trial. But more importantly, there's no indication on the record that testimony, that evidence, that Mr. Nicholson's representation of Mitchell during the trial affected Mr. Caldwell at all. And Ms. Aquara was.
Am I fair to say? I mean, it's sort of, I'm just trying to put myself in the district court's position. He has an obligation both to Caldwell and the witness. They both have rights. He's trying to balance those two. Is that sort of balancing of interest? Is that the sort of discretionary aspect that we see in some of these cases?
Yeah, absolutely, Your Honor. And I didn't find many cases where we had this kind of a conflict. The closest one I found was the Eighth Circuit case, Ramon Rodriguez, which I believe is cited in my brief. And but yeah, it's a balancing of interests. He had to make sure that Mitchell had representation, and he also had to make sure that Mr. Caldwell had conflict-free representation, which he did.
And I think that Mitchell's representation was effective, right? Not somebody
Absolutely.
Knew that didn't know anything about the case or didn't know him, but the person who he knew and had worked with to this point. And I mean, you can see that balance going lots of different ways, but that seems okay. Thank you.
I think that's right. And I think that's probably why the state bar representative said it's okay for today, because it was important for him to have competent representation during that day. And Judge Cogburn was open to the possibility of appointing new counsel and going through whatever he needed to go through to do that. But I just think at the end of the day, we have to ask ourselves if the district court acted within its discretion in the way it handled that challenge. And he did. Judge Cogburn acted very reasonably in protecting everyone's interests. If your honors don't have questions about the remaining issues, I feel like we can rest on our brief, and the government respectfully requests that this court affirm the judgment of the district court. Thank you.
Ms. Aquara?
Yes, Your Honor, the court did address the conflict issue, and Mr. Nicholson indicated that they have a process where conflicts are sorted out. And my question that came up that's in the record is, Mr. Caldwell was the first person arrested. The public defender's office represented him. Mr. Cole's case was farmed out. So it's kind of behooves anyone to see why Mr. Cole, the second defendant, they gave his case to a private counsel, and then Mr. Nicholson came back to represent Mr. Mitchell. And there was a conflict. The court was adamant in allowing Mr. Nicholson to represent Mr. Mitchell. The bar has said, and I cited in the joint appendix, the bar rules 1.10, he cannot represent him. You don't have to show conflict. Conflict is imputed to him. It was the same case. It was the same matter. His office had represented Mr. Caldwell for several years. So that should not have been allowed. If you look at Joint Appendix 103, it shows the stipulation was a conviction where this office had represented him. Mr. Caldwell was prejudiced by Mr. Nicholson continuing to represent Mr. Mitchell. As I indicated, the court allowed Mr. Mitchell to confer with Mr. Nicholson after his direct examination, before cross-examination. He did not even afford that to Mr. Cole, who had his own attorney in the courtroom. So then he was really impacted, and then Mr. Mitchell comes out and testifies differently. The vehicle, the search warrant was obtained, but the search warrant had expired because the search warrant was only valid for 24 hours. The search warrant appears on Joint Appendix 112, that's regarding the vehicle. It shows it was issued on December 10, 2016 at December 9, 2016 at 9:55 a.m. and that it expired on December 10, 12:43 a.m. is what the document shows. That's on JA 112. JA.
What's your answer to the automobile exception?
That's my answer, that there was the case, McCall case said if there's a delay. I'm saying they recovered the car from a property, from a house, and towed it to the law enforcement center. That's why they went and obtained a search warrant. The search warrant had expired. There was no hold on.
I understand, but I'm saying if we don't focus on the search warrant, but assume there was no search warrant and rely on the automobile exception, what is your answer? Or the proposal is that's what we do. What is your answer to that?
I would say there's no automobile exception. Mr. Caldwell was already in custody. The car was not movable. They did see some things in plain view. They went and obtained a search warrant. So if they went and obtained a search warrant, there was a reason they obtained the search warrant rather than searching.
I understand, but let's forget the search warrant. They don't determine the law. The question is, did the automobile exception apply? And if it didn't, why not?
I would say because it was an illegal search, because they also made contact with the owner of the vehicle, which is in the record, Desmond Graham. They could have contacted him because the officer who testified at the suppression hearing said we made contact. They could have gotten his contact.
But the owner hasn't objected. The owner hasn't objected. It's your client that objected.
No, they didn't
but
ask.
The question still is, the argument the government's making is that it did it under the automobile exception. And I just want to know why that doctrine does not apply if you have a response.
It wasn't movable. There was no evidence in the crime. The car was outside at a residence. So the illegal searches without a warrant are per se unreasonable. And I'd ask the court to vacate his conviction and look very seriously at the documents, the North Carolina Rules of Conduct, representation of Mr. Mitchell against Mr. Nickel and Mr. Caldwell in the same matter was a conflict of interest. The state bar rules say you can't do that. It's not for the district court judge to say, I'm not going to follow the rules. He was more interested in protecting Mr. Mitchell's rights than Mr. Caldwell's rights to due process, and will ask the court to vacate the conviction, and as well as the 924C. The indictment, the instructions had nothing to do with knowledge in the interest of justice and to avoid substantial miscarriage of justice to my client. Thank you.
Thank you, Ms. Akbar. I understand you're court appointed.
I am, Your Honor.
Yeah, I want to recognize that it's so very important, as you understand. You did a terrific job, and we very much appreciate your service in that regard. We also would come down and greet you both in the ordinary course, but things are different right now, and we can't do that. But we do, as a court, extend our gratitude for your arguments, and thank you for appearing before us today.
Thank you.
With that, we'll proceed on to the next case.
Thank you.
All right. Mr. Corson, can you hear me?
Yes, Your Honor. Can you hear me?
Yes, sir. What's it, Ms. Herman? Can you hear me?
Yes, I can hear you.
And Ms. Shaw, can you hear me?
Yes, Your Honor.
And Mr. Lampman, can you hear me?
Yes, Your Honor.
All right, we'll proceed with the last case scheduled for today, Plywell versus Morandi, and we'll start off. I guess you have an introduction to make, Mr. Corson. We'll hear from you.
Yes, please. Thank you. So may it please the court, Judge Niemeyer, Judge Wynn, Judge Richardson. I'm John Corson with the Wake Forest Appellate Clinic, and under Local Rule 46A, it's my pleasure to introduce the two third-year soon-to-be graduate students who will be arguing. Thank you for allowing us to tag team on these issues. We wouldn't do this if they weren't fairly distinct issues. But again, back to my introduction, Henna Shaw, Mackenzie Herman will address the first issue in our brief of judicial coercion, and Henna Shaw will address the second issue about the prosecutor's rebuttal closing arguments. I'll do the third issue of the appellate delay. Thank you very much.
Okay, then we'll hear first. Actually, the students ought to recognize that there's a tradition at Wake Forest to win many of these cases. I happen to recall in the past several successes. That's no pressure on you. You take the case as you get it. You do your best. You're advocates. So we'll hear first from Ms. Herman.
Good afternoon, and may it please the court. Mackenzie Herman on behalf of petitioner appellant Mr. Charles Blymale. Criminal defendants are entitled to an uncoerced jury verdict, as stated by the Supreme Court in Lowenfield, and whether a supplemental charge is coercive is dependent on the circumstances, as stated by the Supreme Court in Jenkins. This court's decision in Tucker v. Cato outlines a number of factors that show judicial coercion. And while each and every one of these factors has been satisfied here, there are two in particular that indicate that there has been judicial coercion and the initial conviction should be reversed. One, the supplemental charge in its entirety and context was coercive. And two, the supplemental charge was unbalanced in that it contained suggestions or commands that the jury must agree. Now, before I get into the first point, I briefly want to outline that the correct standard of review here is de novo, and Professor Corzine will discuss the merits of that argument. Now, beginning with context, this supplemental charge did not exist in a vacuum. In other words, that we have to look beyond the supplemental charge when determining whether the trial court was coercive. And when we look at the totality of the evidence here, we see that the trial court judge, Judge Ferguson, set an arbitrary deadline of 2 days to end the trial by Friday. And he reminded the jurors about this deadline at least 5 times. That is before, during, and after voir dire. And while he was advised to expand the jury pool, he simply refused to do so. And even the prosecutor said it was, quote, risky not to expand the jury pool. He said, I think the panel ought to be enlarged on page 1630 of the record. Asked if the case would go into Friday hesitantly on page 1604 of the record. And also asked if the court would reconsider bringing in extra people on page 1631. So this arbitrary deadline was not simply a guideline that was in the back of the jurors' mind. This was something that the trial court judge constantly reiterated to the jury and even threatened the jurors with. If you look on page 1982 of the joint appendix, you'll see that the judge stated he would hate to put the jurors in jail. And these threats are improper under Tucker Factor 2, to be precise. Yes,
Counsel,
Your Honor.
Can I interrupt you? And I understand your colleague, and I'm trying to keep your divisions correct, that Mr. Corzine will address the standard of review, but particularly when you talk about the what you call a threat to putting them in jail, under 2254E1, the Supreme Court here found that that was a comment made in jest. And so we're required to give that factual finding under E1 deference, even if it wasn't decided on the merits. That's a factual finding. And so what I'm having a little trouble understanding is you have a different interpretation of that statement and others, but I just want to use that as an example. Why don't I give deference to that under 2254E1?
Well, Your Honor, the answer is that we disagree that this has been an adjudication on the merits by the West Virginia Supreme Court of Appeals.
Even if it's not an adjudication on the merits, under E1, we still are required independently to give deference to factual findings made by the state court. And the state court here found that the comment of putting him in jail overnight was made in jest. It was not a threat. And so I understand you might disagree with that, but why under E1 don't I have to defer to the West Virginia Supreme Court on that factual issue?
Because ultimately that you'll see under Daniel v. Lee that, pardon me, Your Honor, ultimately they did not actually talk about findings on page 6 of that decision. You'll see in that paragraph, they merely summarize the arguments of the state and Blymale regarding judicial coercion. They don't actually reach findings as opposed to the issue of appellate delay. You'll see later in the case, they do make the finding, as you can see by the statement, quote, we agree with regards to a trial error. But ultimately, they never did reach the adjudication on the merits of this issue. And even if this is a threat, even if we do give deference to the West Virginia Supreme Court of Appeals, Your Honor, this is just one of the many factors of the Tucker test. And we succeed on the remaining Tucker factors, Your Honor. So no matter which way that we look at this, ultimately Plymouth has a very, very strong case because these Tucker factors have been satisfied here, Your Honor. So ultimately, this was not a guideline in the back of the jurors' mind. This was something that they kept hearing over and over. And this arbitrary deadline, along with this threat, set the stage for the trial. And the jurors were keenly aware of the entire time of the judge's anxiety
what
trial.
What your argument, it seems to me, could break down into a couple of components. Judges have a lot of discretion in managing trials. And as a matter of fact, over the years, judges have said, we're only going to take 3 days to try this case, or we're going to take 1 week to try this case, and you guys got to finish. And in this case, the judge did say everything you said, but it doesn't seem like anybody was denied putting on witnesses. So by the middle of the day on Thursday, the case was over in terms of putting in the evidence, cross-examining, and doing closing arguments. The question then becomes, the second component is whether the jury was forced or coerced into reaching a verdict between the middle of the day and the end of that day. And when you focus on that part, one thing that seems to me you may want to address is the jury was explicitly instructed to go back and answer the question whether they thought further deliberations would assist them, not whether they could reach a verdict. How do you respond to that? That seemed to give the jury quite a bit of latitude and tell them they could say no further our deliberations are meaningless, and court was prepared, as we know, to issue a mistrial. But it seems to me there was a pressure contest when to finish the trial, but I'm not sure the jury were actually told they had to reach a verdict. Now, there was, I grant you, the suggestion that they would stay later that day, which is not a good thing. Obviously, how late, unless somebody objected, then it would be a terrible thing. But there was this conversation where the judge was carrying on a dialogue with the jury and said, I'd like to hear from the jury as to whether further deliberations would be useful. And they went back to consider that question. And rather than enter that question, they returned a verdict.
Yes, Your Honor. So essentially, when the jury came back out after 3 hours of deliberation, the judge asked the foreperson if further deliberations would be helpful, to which Angela Adams said no. And then he asked again for a show of hands. Only 3 replied in the affirmative. And at the point, the judge knew the division of the jury was 6-4-2. And he immediately gave his supplemental charge saying, just don't say anything. And immediately after that, they went back to discuss, Your Honor. They came out 44 minutes later, after 3 hours of discussion, with a verdict. So ultimately, that the whole situation indicates that the jurors were very solid in their position, and that this charge did have something to do with coming to an agreement. Ultimately, they did not think they were going to agree with further deliberations. And I see that I am running out of time, Your Honor. So I briefly want to touch on my second point, that this charge did not contain the necessary language of failing to remind jurors not to submit their conscientious convictions, which is complete a failure under Lowenfield and Jenkins. Thank you, Your Honors.
Thank you. All right. On your side, we'll still hear from Ms. Shaw next, right? Is that correct?
Yes, Your Honor.
Okay, we'll hear from you.
Good afternoon, and may it please the court. Hannah Shaw on behalf of petitioner appellant Charles Plymale. I will be addressing 2 points, both based on the prosecutor's closing argument. First, that Plymale's due process was violated by the prosecutor's send a message argument. And second, Plymale's post-Miranda right to remain silent was violated when the prosecutor committed a Doyle error. Turning to the first point, Plymale's due process was violated because the prosecutor gave an improper closing rebuttal argument that urged jurors to protect the community and send a message. In the closing argument, the prosecutor urged the jury to serve a larger social objective and seek broader social approval through its verdict. This goes beyond the role of a jury, as a jury's task is to determine whether the defendant was guilty or not guilty. This court has ruled in United States versus Runyon and United States versus Pupo that a prosecutor's closing argument is improper if it encourages the jury to send a message to the community because it invites the jury to use its decision to not just punish the defendant, but to serve a larger social objective or to seek a broader social approval. Here, the prosecutor's argument was misleading and prejudicial because it repeatedly contained improper remarks about sending a message to the community. It's the jury's role to decide the facts of a particular case and render a judgment for the case at hand. It's not to play the larger role of society. As well, this court has created a 6-factor test as articulated in United States versus Wilson to determine whether a prosecutor's improper remarks require reversal. As to the improper send a message issue, the district court erred in its judgment as to the 2nd and 5th factors. For the 2nd factor, whether the remarks were isolated or extensive, prosecutor's remarks were extensive and not isolated. The prosecutor asked the jury to protect the community and send a message early in the argument, as seen on page 1975 of the joint appendix, midway through the closing rebuttal, as seen on page 1979, and again at the end, as seen on page 1981. The prosecutor's send a message argument was frequent throughout and became the theme of his closing argument, making it extensive. It was not just one offhand statement. It happened at the beginning, middle, and end, and was frequent throughout. As well, as to the 5th factor, whether the remarks were invited by defense counsel had twice stated that rape is easy to allege, but difficult to defend. But this is very different from the prosecutor's repeated arguments that the jury needed to send a message to protect the community. The prosecutor's send a message argument was not made in direct response to defense counsel's arguments regarding the same issue. Defense statement that rape is easy to allege but difficult to defend is very different from a send a message argument. All the prosecutor needed to do to rebut this easy to charge aspect of Plymouth's counsel rebuttal was to simply talk about the burden of proof. And he does that, as can be seen in the joint appendix on page 1976. Since the prosecutor's argument was improper by urging jurors to protect the community and send a message, and the factorial test shows that Plymouth's due process were clearly violated, this constitutes a reversible error. Turning to the 2nd point, the prosecutor committed a Doyle error when he took advantage of Plymouth's post-Miranda right to remain silent. This court has noted that because the nature of a Doyle error is so egregious and so inherently prejudicial, reversal is the norm rather than the exception. As ruled by the U.S. Supreme Court in 1986 by Wainwright versus Greenfield, Doyle and subsequent cases have made clear that breaching the implied assurance of Miranda warnings is an affront to the fundamental fairness and due process clause requires. As well, this case made it clear that a Doyle error can occur in a prosecutor's closing argument. The prosecutor's argument took advantage of Plymouth's post-Miranda silence, which applied because the police had given him Miranda warnings. Moreover, because the prosecutor commented on Plymouth's post-Miranda silence, he committed a Doyle error. This can be seen his remarks in the joint appendix on page 1977, and I quote this saying, quote, "That statement that he gave the police was 3 hours. That he gave to the police was written out was 3 hours later. Do you know there was uniformed policemen in his apartment arresting him 3 hours before, and there's nothing in the record that shows the statement was made to the uniformed policeman, and that the uniformed policeman was subpoenaed by the defendant waiting in the waiting room, and he was never called. 3 hours to make up the story." This is what the prosecutor said when he created a Doyle error. It wasn't simply that Plymouth's post-Miranda silence was merely mentioned, but the prosecutor makes inferences that Plymouth's silence could have given him enough time to make up a story. This is a clear violation. As well, Plymouth's written statement was key evidence, and the prosecutor was making use of it to blunt Plymell's main evidence, as can be seen in the joint appendix on page 1902. As well, using this court's 6-factor test, the district court erred in its judgment as to the second factor of whether the remarks were isolated or extensive. The prosecutor's remarks were extensive and not isolated. The district court's cryptic conclusion that the remarks were isolated because they comprised only 2 short paragraphs of the trial transcript failed to examine the remarks in context. The prosecutor's remarks were made not as a passing reference. As well, the argument that the Doyle error only consists of 2 paragraphs of a 450-page transcript is misguided. Counsel does not talk or guide the argument for the full 450 pages. In fact, parts of trial like voir dire, direct examination, cross-examination are guided by the jury and witnesses. In reality, prosecutor's argument was 2 paragraphs of a 7-page closing argument, which makes it extensive and not isolated. The prosecutor's remarks also...
I don't want to interrupt you and take you back, but I'm going to do it anyway. Back to the send a message comments. Can you respond to the argument that they were effectively invited error? Or in other words, they were responsive to the defense counsel's arguments that were being made?
Yes, Your Honor. This was not invited error. The defense counsel did not invite these remarks. For example, when Plymell's attorney said, "This is dangerous, gentlemen," this did not invite to send a message argument from the prosecution. Rather, it invited the prosecutor to discuss why it was dangerous to men only. And the prosecutor did respond to that. He said, "This is an error of woman." As well, the prosecutor's argument of sending a message.
But those are, I mean, in these types of cases, those are sort of the 2, you might say, underlying, or 2 of the underlying themes that exist, right? And so neither of them probably appropriate. But once the defense counsel raises the "men, you better be worried, if you convict here, you're going to be next" argument, then doesn't that open the door, at least in a prejudice type analysis, when we consider the sort of responsive argument, which is, you should worry about, all women. If you're going to worry about all men, you ought to worry about all women. There's sort of 2 sides of that story.
No, Your Honor, this does not open up the door to having you have to worry about all men, you must have to worry about all women type of argument. Here, the prosecutor ineffectively did respond. He devoted a paragraph of his closing statement saying, this is the era of the modern woman. He responded to that one thing. But the thing is, he went on for the entire closing statement to make this a theme. Instead, what he should have done is that he needed to rebut the easy to charge aspect of Plymell's counsel's rebuttal. And the prosecution, by doing that, he should have raised the standard of beyond a reasonable doubt, and he does on page 1976. Instead of capping it there, he had made this argument throughout the beginning, middle, and end, which makes it more of a theme and less of an invited response. As well, turning back to the second issue on the Doyle error, the prosecutor's remarks attacked Plymell's most important exhibit, his written statement of what occurred in his apartment. The trial judge had previously acknowledged how important the exhibit was, and Plymell's counsel had focused on that exhibit in his closing. This case came down to the accuser's credibility, and her version of what occurred in the apartment was countered by Plymell's written statement that the prosecutor impugned in his use of Plymell's post-Miranda silence. This court should find that the prosecutor's closing argument was improper because a Doyle error was committed. As reversing Doyle error is the norm and not the exception, the court should reverse. Thank you.
Thank you, Ms. Shaw. Mr. Corzine?
Yes, thank you, Your Honor. May it please the court, Judge Niemeyer, Judge Wynn, Judge Richardson. On the appellate delay issue, I'd like to make 2 main points. First is that the West Virginia Supreme Court's decision is not entitled to deference because it was based on a materially incomplete record. And secondly, in the alternative, even if the record was materially complete, the decision was objectively unreasonable. So I have 2 alternative points. On the materially incomplete record, the record was materially incomplete because it was lacking evidence from the important years of 1994 through 1997, the important early years of the appellate period. And collectively, what's missing from the record before the West Virginia Supreme Court shows that the first appellate attorney committed several ethical violations. The trial judge took many months to appoint a second appellate attorney, finally doing so after a writ of mandamus from the West Virginia Supreme Court. Then the trial judge and the prosecutor entered two improper ex parte orders that frustrated Plymell's right to appeal. And then his second appellate attorney basically abandoned him, stopped communicating, left the public defender's office without telling him. And this covers the period of 1994 to 1997.
I hate to do this, but I'm gonna do it again.
No, please do.
Before we get, I get the facts and I understand, but hypothetically, assume that I agree with you that this was a due process violation, right? That taking 20 years to decide an appeal is a due process violation. For you to get relief under 2254, your client must be in detention as a result of that violation, right? And so what I'm having trouble seeing is that even if there's a constitutional violation, now that the West Virginia Supreme Court has decided it, we talk about in Johnson is sort of a mootness type analysis, but given that the appeal has been decided, I don't understand why your client can argue that the delay is the reason under 2254A that he's in custody and thus entitled to habeas relief.
Certainly, Your Honor. And so the sort of remedy relief question is obviously a valid one and an important one. To answer it first, I'd like to say when he filed this federal habeas petition back in 2014, he was still incarcerated. In fact, it took another almost 2 years for the West Virginia Supreme Court to decide his case.
And that may well excuse exhaustion in some other context. I understand that, but what that doesn't tell me is why he's in detention as a result of the due process violation.
I see what you're saying, Your Honor. Well, again, when he filed this federal petition, he had not even had his direct appeal decided. And so he cited the numerous cases in the lower court that after a certain period, he sought a writ of unconditional release due to the appellate delay. And there's some authority for that. I do not have it in front of me. So the theory was this delay has gone on so long, is so extraordinary, he's entitled to a writ of release. So that was the theory when he filed.
Right, but that's what I'm having trouble with. So the courts, and there are lots of courts that talk about there being a due process violation. I'm thinking of Cody versus Johnson out of the Second Circuit as an example. Our decision in Johnson, which isn't an appellate issue, but it's the same one, that there can be a due process violation, right? But the due process violation doesn't result in the illegal confinement. There has to be an issue on appeal that would have prevailed in order for the due process violation to result in his confinement. And that's what I'm having trouble. And then that goes back to your colleagues' arguments. I understand that. But what I'm trying to figure out is the appellate delay issue an independent issue at all? Even if it's a due process violation, I don't see how that's the reason for his detention as required to get release.
Right. Well, we contend that it is, Your Honor, and I'll get back to that in a second. But certainly, my colleagues, as you say, we contend that either or both of those issues are reversible error. And so, if that's the case, it's sort of a separate point whether it needs to be a standalone claim. But again, at the time of filing, the delay had been well over 19 years, and his theory was, I'm entitled to unconditional release because this has gone on so long. Now, of course, we have had the West Virginia decision, and so now circumstances have changed to that extent. And again, I argue both that it was based on a materially incomplete record and also that it was objectively unreasonable alternative.
What relief would you want right now?
The relief, yes, Your Honor. So both sides cross-moved for summary judgment. and the court agreed with respondent. So we would like that reversed, that in fact, the certificate of appealability was due process violated due to appellate delay.
I understand, but let's assume we go through this habeas process and conclude there was a due process violation that should not have occurred. We reverse the conclusion. What's the relief you get?
So I believe
habeas traditionally addresses custody.
Yes, Your Honor.
Would you want the man? Is he still in prison?
I believe he was released earlier in 2021, Your Honor. Finally, in this year in 2021.
Yeah.
Correct.
Okay, let's assume he's still in prison just to carry out the argument. What relief would we give him?
Well, that could be released if that could be released.
Why could it be released?
Because
the appeal can go one of two ways. He can win and lose. If he wins on the appeal, he gets a new trial. If he loses on appeal, that ends it. Now, in this case, it ended it. But in either case, it doesn't release him from custody. This goes back to Judge Richardson's question, I suppose.
It does, Your Honor. And if I had a better answer, I would give it to you. I think it would be important for this court to recognize the violation that is bound to have collateral consequences. It perhaps also this would be important precedent for courts going forward. And I think the precise exact relief as to where he is now in his life is probably a better developed on remand. I don't think here today we can come up with the best relief in what his life situation is right now. It's not.
So let me ask the question because it's just puzzling me a bit. You just revealed to me that he is not in custody. And I wrote a dissent in U.S. versus Wilson dealt with those soldiers, those sailors down there that they wouldn't give him relief on the sexual offense type situation where registration because say they weren't in custody anymore and they got anything, even though everything showed they were innocent. Is there any tie? I mean, how do you give habeas relief if it's not in custody? Help me out. I mean, it sounds like I should have prevailed in that case. So, Your Honor, my understanding is this does not moot the case as long as he was in custody when the 2254 was filed, which was 7 years ago, and he was in custody until very recently. We do not have a mootness issue, and I think relief ought to
we don't have a mootness issue, maybe, but we have a substantive habeas issue. Habeas is intended to release from custody. Now, I suppose custody continues with supervised release, and maybe not, depends on the state law, but it's
well, it's troubling to me because I'm not sure Wilson wasn't under some type of supervision. I'm just, I mean, it's the first time it came up. It's the reason it didn't come to my head because it looked like me, he was still in custody, and I'm not saying it's an issue, but it sounds like to me that's something because this is habeas relief that you are seeking. And as Judge Niemeyer was pointing out, how do you get habeas relief? It's not direct appeal in this instance because he is gone. I mean, what we do is we free you, but he's out.
So let me give you another, again, I believe this is better explored on remand, Your Honor. Let's say Your Honors did agree on one of my-
Oh no, that would be a matter of law. We've got, I mean, we can't, I wish I could have sent it back on Wilson said go back on remand to deal with it. But I'm just thinking, I'm just saying, it may be a supplemental brief situation, but it seems like to me, unless someone knows the answer, and maybe an obvious answer that comes out, but I thought it would leap from your lips to me and say, Judge Wynn, you're completely out the rocket. You can't do this. Now, I got if the answer is at the time you file it, you're in custody, but I don't think that follows. I think you've got to be in custody because I'm trying to think of the relief you give as Judge Niemeyer. I don't want to muddle this thing, but I'm really puzzled about that right now because it's the first time I heard it. I did not know he was out.
Right. No, certainly, Your Honor. So a couple of things with a minute or two of indulgence here. First, if you agree with my colleagues on either of those issues, then he would be subject to retrial. And one of the reliefs he has sought, I can't cite you joint appendix pages, is that due to the extraordinary delay that's gone by, the state should be barred from retrying him. So that's a potential collateral consequence, for example. But again, and I don't know if the court wants to give me additional time to talk about the Barker factors. The Barker factors do not speak to this.
Well, I'm still stuck on that one because I'm just trying to get Wilson off my head, because everything you're telling me, Wilson had been actually found not to have done it. I mean, that was what, and it was a collateral thing that was being done to him. He was required to continue to register as a sex offender in another state, and the court said he hadn't done it. So come to us for habeas relief. It says, no, he's not in custody. If he was in custody, then we could give him some relief. It didn't make any sense at all to me, but I was a dissenting opinion. So, and I followed the law. I mean, it's the way I would like it to be. But if it's not that way, I'm going to do exactly what I've been told the law is in the circuit till someone tells me different. So that's why I say it's important, at least for somebody to come up with something. And maybe, I guess you guys got a little time. Maybe if you can score around and kill that point for me, I can get off of that, because that would end this case.
No, certainly, and thank you for making that concern explicit. I will say, it sounds like your dissent in Wilson was correct, and maybe there's a way to distinguish.
No, it wasn't. It didn't prevail. It may be the parole. It may be the parole thing he's trying to get out of. I don't know. I'm just saying, I just don't understand. But that's the first I heard he's out. That's the only reason I brought it up.
I missed what you said, Judge Richardson.
I think it's the difference between supervision and registration, but
that may be, Judge, and I agree with you. It could be that, but it was the issue was whether he was in custody, and and is supervision in custody. That I may have answered that back then. I just don't remember it right now. You caught me off guard on that one.
Well, I was asked about it, and certainly didn't want to not point that out to the court. Again, the case has been ongoing for now over 7 years. Would the court like to ask any other questions about the appellate delay issue? I didn't really get to my points, but they are in our briefs. If the court has.
I think we've got it. Yeah, it's a complex factual record on that. It actually surprised me. 20 years is a long time on appeal, but anyway, I don't have any further questions on that. Judge Wynn, Judge Richardson.
No, I'm fine. Thank you, Professor.
All right, why don't we hear from Mr. Lampman?
Thank you, Your Honors. May it please the court. Thomas Lampman on behalf of respondent. The district court correctly rejected petitioner's claim that his due process rights were violated by the delay in adjudicating his appeal, and the district court correctly reviewed that claim under the deferential standard that EDPA requires. The district court also correctly concluded that petitioner's other two claims did not have merit, although the district court should have reviewed those claims under the deferential standard set forth in EDPA, and indeed should have dismissed those claims as procedurally defaulted.
Can you start where we ended? Do you agree that he is no longer physically in custody? And then second, can you tell us anything about whether he is under the degree of supervision required to be considered, quote unquote, in custody under the Supreme Court's Jones decision from the 1960s?
Yes, Your Honor. Although the facts aren't in the record, as it has been explained to me at least, petitioner was released on supervised release, I believe several years ago, but is currently incarcerated again in connection with a separate offense. So he is in custody, but the custody relates, for purposes of this case, more to supervision than to confinement.
What was the nature of his supervision? Is it analogous to the federal supervision, or what is it?
I'm not aware of the specifics, Your Honor. I believe that he was, it was subject to revocation for future offenses, and then there was another offense that he
sort of a probation
or allegedly convicted. Yes, Your Honor. But again, I don't have the record of
well, I know
that
this
portion
is,
of his
I
criminal
think
filing.
This is to all of us right now, and it's actually an important fact, I think, for us to consider.
Yes, I would agree with that, Your Honor. I'm aware of, as Judge Richardson pointed out, that when there are elements of supervision still applicable to to a person, they're still confined and can still seek habeas relief for that reason. The important point I think here to note is that for purposes of appellate delay, at least, petitioner is not confined because of the appellate delay. As the West Virginia Supreme Court noted, his appellate delay claim did not prejudice him. There was no merit to the underlying appeal that he sought to bring. And as a result, he has already received any relief he'd be entitled to because of that appellate delay. He's already received the appeal that he would ultimately have been entitled to. This court has already waived the exhaustion requirement for it to review the underlying merits of his claims. Beyond that, there's nothing in the Supreme Court's precedents that indicate that he is entitled to release for no other reason than the adjudication of his appeal was delayed. Again, that does not cause him to be incarcerated. He is incarcerated subject to a valid conviction, a conviction that's been upheld on appeal. It's set forth in our briefs, Your Honor, our dispute with the factual characterizations of the Supreme Court of Appeals decision. So just to briefly address those, the factual record is not materially incomplete with respect to these concerns. The only documents that have been suggested as being omitted from the Supreme Court of Appeals' record deal with a very short period of time in the mid-90s. They don't speak to the vast majority of the time petitioner was not pursuing his appeal. They don't speak to any of the time petitioner was under his own volition not pursuing his appeal or was prevented from doing so by illness. Does not dispute or does not disrupt anything to do with the court's conclusion that that time was not chargeable to the state. So
let me ask you, go back to a question that was brought up. Judge Richardson had alluded to the fact that the Supreme Court of West Virginia said something was in jest. Was that a finding actually by that court, or was it just a comment by the court?
Yes, Your Honor, that deals with the
Is it a finding? Is it a finding?
Is
it a finding by the court? And if it is, what's the evidence that supports that?
Yes, Your Honor. That is a finding. That is a factual conclusion. That statement is not a mere recitation of something that was contained in the state's briefs. But the court editorialized when it made that comment when it said these statements were clearly made in jest. There was no caveat on that sentence saying that respondent argues it's clear.
But if you read the court's opinion, it's not a typical opinion. It looks like it goes from point to point. And on that particular point, it raised and summarized the arguments of counsel. And then I read by implication, it accepted the state's position, but it never said so. When it referred to that particular statement, as I recall, it was summarizing the state's argument. Now, I think implicit was that it accepted that argument, but maybe not so. That could be debatable. I don't know. I think that's Judge Wynn's question, isn't it?
It surely is. I mean, it's clear they're just summarizing the state's argument at that point. I don't think they made a finding. Even if it made a finding, I'd have some question as to how in the world do you make that based upon the cold record? When based on one said that, if you read for what it is, there's no joking in that. There's no one laughing or anything. Plus, I have a problem with a trial judge joking in a case like this anyway, but that's a whole different thing. But I get it. I'm not going to go back and try to sit in the place of the state judges. I was one of those myself, and I particularly don't want to go against them and sin. I'm going to take them for what they did, but I just don't see it there. I think the best we can say is they were summarizing the state's argument. I will accept that, but I don't think it was a finding.
I would contrast the finding in that portion of the opinion, Your Honor, with other portions of the opinion, again, specifically because it contained editorial language. Rather than saying respondent argues point A, respondent argues point B, respondent argues point C, it's set forth at the start, respondent has argued that these statements are not prejudicial. And when, again, in characterizing that statement, the court did not say petitioner argues that this was clearly made in jest. But the court itself said these statements were clearly made in jest, full stop, without any qualifying language. It was in a paragraph that's at least certainly started by summarizing the state's argument. But by that point in the paragraph, there was the court was putting its own assessment of the facts on how it characterized them. It's worth noting that with respect to that argument and with respect to the prosecutorial misconduct argument, the findings are not as clearly stated as you pointed out, in large part because the Supreme Court of Appeals ultimately held that both of those claims, judicial coercion and prosecutorial misconduct, were barred under a state procedural rule, common rule of the contemporaneous objection requirement. This court has recognized in Davis v. Albrookes, Daniels v. Lee, that applying the plain error standard.
Before you go too much further down the procedural default argument, I think it's a great argument. It's just not one you made below, right? I mean, you cited one sentence that does not at all make the argument, and so I mean, why are we talking about an argument that you didn't make below? It might well be the right argument, right? But it's not the one you made below.
This court has acknowledged in several cases that even when an affirmative defense like procedural default is not raised below, this court nonetheless has discretion to consider that defense and to rule based on that defense.
I don't know where that is. There's direct law in this circuit that says the other way. You didn't make that. I mean, it's a recent case just came out. U.S. versus Harris just came out and said that right on point of what Judge Richardson is saying. I think he's probably right. It is a great argument. You just didn't raise it. If you didn't raise it, which is, I didn't hear it from the other side, so I assumed it was just moved on, and you seem to not have brought it up very much. It's sort of come and pass in a reply, and I don't think it's there. I think that one my opinion, I mean, but maybe you can get around U.S. versus Harris.
Just to clarify, I'm not sure, did that case overrule Yates v. Angleton or Anglin? Because I believe in the Yates case, this court held that where a procedural default argument is not waived but is inadvertently forfeited, that the court has discretion to consider it on appeal.
So back at that question for a second. But why would we recognize? We assume we've got some discretion. Tell me why, in a case like this, we would use our discretion to excuse your waiver.
There are the three factors I would point to, Your Honor. First would be the distinction between waiver versus forfeiture, where the state, as in Yates, where the state made the substance of the procedural default argument below, but did not specifically articulate or specifically invoke procedural default.
Let me just be clear. You didn't argue that either. You didn't argue this is an exception case. You didn't argue that. What you're saying now, you didn't argue this. In terms of the substance of procedural default, Your Honor, in ECF page 1189 in the state's, I believe, second amended answer. Well, all I'm saying is you didn't argue it was a exception case. It doesn't seem to be there. But I would like to know, how is this case different from U.S. versus Harris? We just handed that down.
Again, all I can point to, Your Honor, is Yates v. Anglin, Royal v. Taylor, the comedy.
I understand that, but then Harris must be wrong. You're trying to say Harris was wrong and we should do something about it? I mean, it's on point. Those cases aren't on point as Harris is. It's right on point.
Again, all I have for you, Your Honor, is the state's position that Yates is more on point, that incomplete, but Yates held that the state, beg your pardon, Your Honor?
Yeah, I want to know what it
So in Yates, this court held that the court could consider procedural default, even though the state had not expressly raised the argument below. when the state both believed it had, when the state had articulated the facts that would form the basis of a procedural default argument. In that case, it was, as in this case, the failure to object below.
Did you make that argument
Beg your
here
pardon?
that procedurally that they couldn't make this argument?
Yes, Your Honor. And in ECF 1189,
What did you say?
one of the state's motions, the state pointed out that the West Virginia Supreme Court held that because this claim was, these issues were not objected to at trial, the West Virginia Supreme Court dismissed them on the plain error standard. The precise way that that procedural rule is enforced pursuant to Davis and Daniels.
Well, that's just a factual argument. The question is, how did you get to the next step? What did you say substantively that said it should be under the default rule?
The filing went on to argue that the disposition under the plain error standard was correct and that it was handled in the correct way as a legal matter.
Can I just
ultimately, Your Honor,
to throw you a bone, the distinction with Harris is that Harris is a federal habeas case where Yeats relies upon federalism and comedy to give us the discretion to do it when we're reviewing a state court, even where the state executive branch fails to do their job.
That is an important distinction here, Your Honor.
But keep in mind that the exception that's articulated is for exceptional cases. You didn't argue that. So even if you get there, you're giving us nothing to go with discretion on.
In terms of whether the comedy concerns here do relate to the interest of the state court rather than the state as a party, which alters the calculus from that standpoint, would be an additional reason to exercise discretion. Nonetheless, the fact that these matters were fully briefed below or were fully briefed before this court, leaves the court with the ability to decide this issue. There's not a concern that the issue is being addressed summarily, as was the case in Royal or in other cases where there cannot be a comprehensive adjudication on the issue. Nonetheless, although the district court and the magistrate court noted that this was likely an appropriate way to handle the case and then declined to do so, the court did ultimately reject both the petitioner's claims under the de novo standard of review. We would argue that a deference under EDPA would have been appropriate here. Assuming that procedural default is waived, the comedy concerns necessary to enforce a state's procedural rules and otherwise informing the federal habeas jurisprudence are nonetheless present in the state court's disposition of these issues.
Does it make a difference, counsel?
And under that deferential standard?
Counsel, does it make a difference, assume for our hypothetical that you failed to raise the issue below? However, the magistrate judge and the district court both addressed procedural default. Even though you failed to do it, those judges did. And so does that make a difference, your failure to raise the issue, given that the judges both below addressed procedural default? Does that make a difference?
For purposes of appellate review, Your Honor, it does help. Again, one of the concerns underscoring the decisions in Yates and other previous cases was whether there's a sufficient record for this court to rule on. So the analysis of those courts does lend in favor of resolving the issue now. The district court declined to rule on procedural default, noting that they would rather rule on the merits than on the.
Then let's be clear about it. The district court did not address it. Then, if it declined to address it, as you just said, that's not a basis. As I understood Judge Richardson's question, if the district court did rely upon it and dismiss that reason, could we deal with it? You just candidly admit it, and I think the record upholds it. They didn't address it. He didn't address it.
Correct. They although they analyzed it, it's not a dispositive portion of the whole thing. That's true, Your Honor. They noted
they comment on it, but it wasn't part of the holding at all. It was a throwaway, and probably didn't comment on it, didn't make a holding because you didn't raise it. There's no reason to bring it up. And there's only so much the court is going to do your job. I mean, we go out of our way trying to help the government in cases, sometimes much to my dismay, but, there's a limit. You didn't even bring it up. So these judges wisely looked at it and said, oh, no, you didn't bring it up. I'm not going to make a finding on something you didn't even bring up. And even to that point, didn't bring it up, I guess.
So the basis of the state court, the district court not considering default was not so much that it was not raised, but the court expressly noted that it was because it's improper to rule on procedural default or disfavored to rule on procedural default when the procedural question turns on complex questions of state law and where the merits under federal law are straightforward and the case can be disposed of that way. It's a comedy principle that that does cut in favor of ruling on the merits, but nonetheless, the procedural question here under state law is fairly straightforward, as set forth in the Supreme Court of Appeals opinion.
Can you?
Nonetheless, we don't disagree with the
counsel. Sorry to change the subject and talk about the prosecutors. Send a message. Don't worry about your daughters when they go to college. Arguments and why you think that those were either proper, invited, or non-prejudicial. Whatever you think the best argument you have for.
Certainly, Your Honor. The best argument on that point would be U.S. v. Young, whether viewed under the deferential standard of AEDPA or conducting de novo review. In that case, the Supreme Court held that the context in which you view a prosecutor's statements can determine the propriety and in particular the prejudice aspects of this inquiry. And where a statement is made by a prosecutor that is in response to a statement made by a defense attorney in closing, even a statement that would be considered improper in other contexts, it's not prejudicial because the jury understands the connection between those two statements rather than simply focusing on the content of the prosecutor's statement in isolation. So what we have here in this case, the defense counsel's closing made several references to what we could describe as broader societal concerns, described the case as a dangerous case, invoked the inherent unreliability and the ease with which these accusations can be made in sexual assault cases, and articulated again to the jury that this was a dangerous case for these broader societal reasons. The points made by the prosecution were only made on rebuttal, were not in any way raised in the initial closing or at any other point in the case. And proceeded as sort of through a factual, statistics-driven response to the points raised by defense counsel, culminating with broader societal statements similar to the broader societal statements made by defense counsel. That's exactly in U.S. v. Young. There was even the same type of language about telling the jury to do their job, the same sort of entreaty to think in a more societal focused way, to focus on their role as a juror as a way of influencing society. Those same comments, again, when they're made in response, were not prejudicial because of that direct relationship. The other factors in U.S. v. Wilson, dealing with prejudice, turn heavily on that relationship. setting aside the question of whether the statements were just improper on their own. But as to the other factors, whether these statements have a tendency to mislead or divert attention, again, there's a close relationship between where there's a close relationship between the two statements. Those concerns are not as strong.
It was a particularly difficult case. I mean, I've gone back and read through the case itself and the facts of it. This jury came back initially 6-4-2. We don't know which way. Facts were pretty interesting on both sides of this, and very, very involved type case. This prosecutor gives this very short argument. It was a short closing argument, and a great part of it are these send this a message. And it's not just send a message. It's pretty strong stuff. I mean, this is not just you send a little message to the community stuff. Oh, he went there. And he went there in a way I hadn't seen. I don't know. I'm not sure I've ever heard Judge Richardson do that when he was prosecuting cases, and I'm not saying that would be an example of how to do it, but I think he's a model of how to do it. And it's pretty strong. I mean, he really goes there, and even if it's invited, there's no curative instruction by the court on this thing here. It's really troubling when you look at this and you look at the evidence. If it's a clear-cut, hard, strong evidence going just one way, but here you got a case where there's a lot that's here. I mean, you got this student that's at Marshall University, and he meets another, I guess, lady, a student, and unfortunately, they get in a consensual situation, and then it goes bad. And then that's where the gray area, because it's a jury determination as to what actually happens. But it is, I mean, that's some strong evidence on both sides of this case. But that prosecutor's argument is pretty, you know, and that much I probably will assume that in West Virginia, he probably has some knowledge of who is here. I mean, and the community standards and that thing. It really pushed it. It looked to me it did a little bit more than just push it. It was pretty strong. How do you? And you are you painting the picture that, well, it wasn't all that bad. It was something they kind of invited because it said something about men. So now he can just go full Monty there in a very short argument, by the way. It wasn't a long argument where it's embedded somewhere in it. It looks like to me that's the meat of his argument.
The close relationship between the two statements is what I would point to, Your Honor. I would agree that it is a very strong statement, and
that's being kind. That's being kind to him to say it's a strong one. I just don't want to go there and make a complete judgment on it. But I could use stronger language than strong on it. To be honest, it's out there. That's all I can say for a case of this type.
And what I would point to, Your Honor, as a comparator would be the statements made by the prosecutors in U.S. v. Young, where the Supreme Court dedicated a large portion of its opinion to specifically deconstructing the many, many problems in those statements. Not to reinforce specifically how improper those statements were in isolation, but then the ultimate holding of that case was that they needed to be viewed in context, if they were invited, if they were proportional, and the other factors that we discussed. So it's not to minimize your concern in any way, to acknowledge that fact can be true, but that it doesn't warrant reversal.
Well, I don't want to overstate it, but it seems like to me, if a prosecutor is allowed to do this, you really don't need to talk about the facts very much. I mean, if you can take a case like this and run in a short argument on this, you can get some good conviction. If you can get them to start looking toward their prejudices and then their local feeling, if you don't find this petitioner guilty, he's going to encourage these sadomasochistic people to run wild, and there's no evidence of that in the record. I mean, I'm bothered by it. Let's put it that way. And I don't want to say I prejudged anything. I'm just saying I'm bothered by it at this point. And I'm not sure you are answering my concerns, so I'm inviting you to do so.
It would be a concern certainly if the closing focused heavily on these points. Again, the opening of the first part of the prosecution's closing statement did not in any way reference any of these points. Was very specifically focused on the facts of the case, weighing the relative credibility of the victim versus and the other witnesses versus the defense count versus the defense's case. Beyond that, the proportion of these statements, intense as they may have been, weighed against the other facts that were presented, the weight of the evidence that was presented, and to get the close relationship between what defense counsel said and what the prosecution rebutted those statements with. That's what I point to as weighing against that concern, or as miliating against that concern. It's certainly true in another case where these statements are made without any of those other factors, that would certainly create a problem. To briefly address the judicial coercion point, again, this is a standards, multi-part standard. One of the factors in particular I'd want to point to is, how is it that a reasonable jury would have interpreted the statements made by the trial judge? The most forceful statement the judge made shortly before he sent the jury back in to see if they could reach a conclusion was to remember what I said earlier about pride and stubbornness. And if we're looking at a juror, even under Tucker, even a juror who's in the minority and who hears a charge not directed to the minority, but they nonetheless understand as referring to them, a juror who heard that would have known to think back, that would have reminded that juror that they had heard those words before. That instruction referred back to the initial instruction.
How is that helping you? That the judge is telling him he's got a 642, he knows the numerical breakdown, and then he tells him, he's already told him, we want you out of here. We got people that are got to be gone tomorrow, and only three of the people says we can reach a verdict. And he sends back and tells him, now don't be stubborn and don't be don't be so fixed. I'm on a paraphrase in terms of how you think about this, and it looks like it's directed to those in the minority. And I don't know which way it goes, but it looks like it. I mean, how is that helping? I mean, isn't that one of the factors that we consider?
It is, Your Honor. And I see my time is closing, but to briefly address that point, that phrase refers back to the language used in jury instruction 6, which specifically directed jurors to not surrender their own convictions. That is the phrase that in other opinions has been held to be, if that language is missing, it can be seen as an inherently fatal flaw in the jury instruction. But that not only was that language used in the initial instructions to the jury, but it was then called back to in the later instruction, the instruction that's described as problematic here. If there are other questions as to the elements of the closing, I'm happy to address those.
Mr. Corzine.
Thank you, Your Honor. I'd like to make 3 points, one about procedural default, one about coercion, one about the send a message argument. On procedural default, I'd really like to try to put a stake in that. Not only was the Harris case decided just a couple of months ago on that point, Harris, to follow up on Judge Richardson's question, Harris was a federal case, but it relied on the Royal case, which was 2254 out of Virginia. And even more importantly is Wood versus Milliard. That's Supreme Court, and it's a 2254 out of Colorado. And in Wood v. Milliard, which we cited in our reply brief, the court there said language similar to what the state did in this case in district court was a waiver. In that case, the state had said they would not challenge, but they were not conceding a limitations defense. Well, here on pages 1 and 2 of our reply brief, we quoted the state, I think Joint Appendix page 754, even stronger language that they were not raising a procedural bar. So that is just waived, and there's both Wood v. Milliard and not just Harris, but the Royal case before that. In addition, the rules governing 2254 actions, which are freely available, they're on this court's webpage, the rules governing 2254 actions, Rule 5 talks about the answer, and it says you've got to put in your answer things that include exhaustion, procedural default, statute of limitations, and non-retroactivity. Those things are supposed to be decided up front, not 7 years later. And in fact, the state here pursued exhaustion heavily. There was a prior appeal that this case decided in 2016. It was again briefed in district court through 2017. We've been down the exhaustion route exhaustively. The state shouldn't now get to bring up procedural default. Secondly, on coercion, I'd like to say a couple things on that. First, it was the factor is actually threat or suggestion that the court would keep the jury until they reached unanimity. If you look at this court's factors, it doesn't even have to be a threat. It could also be a suggestion. Here, the gist, we again say a close reading of the opinion, it was not a finding. It's clearly a summary of the state's argument, not any sort of finding. Therefore, what the court did find on coercion is that there was no plain error. And under Daniels, that's just not an adjudication of the merits. Judge Richardson's recent opinion in Valentino actually said it's whether there has been an adjudication on the merits is determined de novo by this court. And so we would ask the court to disagree with the district court here that there was any sort of finding about or disagree with the West Virginia court with any sort of finding. Finally, on send a message, this was not invited. I see I'm going to have to go over a little over time with the court's indulgence. Send a message was not invited. If you look at the defense counsel closing, it was very long. It was very factual. Went into great detail on the facts. He started off by saying a man's liberty is at stake in this case. The facts of this case. He made one passing reference out of a very long closing to this is dangerous, gentlemen. The prosecutor responded to that, as my colleague Ms. Shaw said. The prosecutor said this is an era of modern women. That was enough of a response. But he then went very disproportionately, not all out of all proportion, to keep talking about sending a message. Unless the court has questions, we thank you again for your indulgence on this three-way split and for your time. Thank you very much.
Thank you, Mr. Corzine. I note that you're court appointed, and I want to recognize that. That's very helpful. It's very necessary, and it makes our system work. And that the rest of the world, I think, envies. I also want to recognize the very good assistance that you had with the new lawyers, the new budding lawyers. We trust we'll see them again. And at that time, we'll have our custom back in place where we can come down and greet counsel. I want to thank everybody, state and petitioner, for their arguments. We can't greet you and shake your hands, but that is our custom, and we do it abstractly here, so to speak. Thank you very much, and we'll adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you.